Ready to take your verdicts and jury selection to the next level? Jury consultant Harry Plotkin and trial lawyer Dan Kramer are your ticket to tipping the scales before trial begins. You're not just picking a jury, you're picking justice. Produced and powered by LawPods.
Welcome back to another great episode of Picking Justice. Harry, how you doing, man? How's the soccer refereeing world going out there?
Oh, it's a lot of fun. I did my first investigation of a referee from a coach complaint. I'm sure it'll be the last one. Coaches are...
Wait, what? Wait. You, what happened?
The soccer field, youth soccer fields are more contentious in the courtroom. I mean, I can't tell you how many times I've had coaches screaming at me, parents screaming at me, even for calls that I've made. Like, they're like, oh, you didn't do it quick enough. So yeah, I have to occasionally investigate issues with referees or complaints about referees or coaches. So,
well, hopefully we can make peace here because we brought a soccer coach on for you here, Harry Plotkin. The great Kurt Zaner from the beautiful state of Colorado, where I spent my 4 college years at the great University of Colorado, Boulder.
Don't understand 6 college years, right? Don't undersell yourself.
Only 4. Who only does 4?
yeah. Well, it's time they go to school for 9 years. They're called doctors or lawyers. Anybody know the movie?
Tommy Boy?
That's right. There you go.
There you go.
No, but we have a very good friend of mine, truly an amazing trial lawyer. I'd like to say up and coming, but I think he's already there. Kurt Zaner, who's hit for, I think, the biggest personal injury verdict in Colorado. He's hit for $16 million, $30 million. He really is just the go-to trial rock star in the state of Colorado. But you're trying cases all over the country now, aren't you, Kurt Zaner?
I am. After I shared a stage with Dan Kramer at TLU, the referrals just started coming in. You know, they realized
they must all go to you because I'm only trying cases in little old California still.
I'm getting looks from around the country, which is great. None of those have matriculated into trials yet. Hopefully soon. I just got on a 6-week trial. I don't recommend that. That's really long.
Yeah.
Harry gave me some sympathy on my Facebook post when I was in the, I don't know, 3rd stage of grief or whatever it was, because I lost my first trial loss. I guess everyone should do it, but maybe not lose your biggest, largest, scariest case ever. So that's okay though. I'm working through the pains and we're okay with that. But yes, I get cases from around the country. None of them gone to trial yet, but yeah, we're getting looks everywhere, which is awesome because I love to go take our show on the road and our little traveling circus.
Yeah. Look, I've lost cases. Every great trial lawyer I know loses cases. It's business we chose, and it makes us way better trial lawyers. I'm sure you've already learned so much from that one, Kurt, than any of your wins.
That's right, because when you win, you did it all perfectly.
Yeah,
what could
exactly.
possibly need to be changed? And then when you lose, you did everything wrong. And so you get lots of time for reflection. And that's it's been 6 weeks of recovery. Now, I can't wait to get back in the court.
Yeah, man, that's the biggest thing is getting back in there. But let's talk about jury selection. So in the great state of Colorado, unlike other places, jury selection is done how, Kurt?
So, I mean, the standard, and this is for all PI cases, and I guess other cases, I don't do other cases, so I wouldn't know. But they start you off with generally 15 minutes is what everyone gets. Federal court, I've gotten 20 minutes, woohoo, which maybe is more than some other states give you in federal court. But 15 minutes presumptively, I always argue for more. I have been successful to get between 30 minutes, sometimes even up to an hour. But that's really as much as we get. In this last 6-week trial, which was 6 weeks, if I mentioned that, we got 90 minutes for 4 plaintiffs. And the judge thought that was giving us a gift. So we are used to getting in and getting out in 15 minutes to 60 minutes. And 45 minutes is probably what I generally get the most, but I'm used to 15 to 30 as well.
And how many jurors is that for?
So in Colorado, they seat usually 7, 1 being an alternate, and then six deliberate.
Okay, so that's obviously smaller than California. So 7 jurors, but then how many are in the veneer, so to speak?
Usually, right, and I just did one there too. It's they only do the number that you would need for the strikes and the alternates and so it's like whatever, 18 or 16 or 20 or whatever the number is, depending on how many alternates you have. Yeah.
Right, exactly. You each get usually 5 strikes, and so they put enough in and then work backwards, and so it's like 18 or 19.
And if you lose someone for cause, they just put another one in there, and
that's right.
You lose them again. Yeah,
that's
you
right.
Get your 30 seconds.
It's the worst. I had this in our last trial. You spend all this time with everybody else, and then someone comes up, we give you a minute with the new juror. Okay, anything you want to tell me? It's usually how I start with those, because it's like maybe they've got some things they really need to tell you, and you can't go through everything. You don't get a chance to meet them. And I mean, those are I mean, hopefully, depending how the judge does it, your alternates, because they're coming up last, but every judge does it differently. And that is a real challenge. We can talk about that later, but
How many people
tough.
are in the panel though? Like the panel that's being called up?
Anywhere from, depending on how long the case is, anywhere from like 50 to 100.
So let me get this straight. So you have 15 minutes, not for the whole room, right? It's just for your entire jury. So you're questioning the first 18?
Correct. You
Okay.
only talk to people that are sat presumptively in the box. Colorado's not great for cause challenges either. It's so judge dependent. And so, I mean, most judges are really bad on cause, and they just can rehabilitate anybody. Can you follow the law?
Yeah.
Great. You can sit in our jury. And so you don't, maybe they just think that that's all you're going to need. And so you can only talk to those in the presumptive box.
Okay. And then after you're done with them, you say you get an extra 30 seconds for each new person that comes up.
All depends on the judge. Usually I'd say a minute is standard. In our last trial, for the alternates, we got 10 minutes for 4 people. You're just blasting through topics. It's tough. At that point, you're just trying to find any toxic juror. And is this person worse than the other people in my box? Good luck trying to build a foundation to get those people for cause. You'll use up all your time just starting to explore it. So you're just going, when you have limited time, the things that are important to me are any kind of anti-plaintiff bias, tort reform lovers. We want to get rid of those people. And then anyone who's not comfortable with awarding large sums of money. I mean, those are really the 2 big things I have time to hit for the for-cause substitutes.
So walk me through you get up there, and what's kind of the first, because you don't have time to spend, like some people teach, like 20 minutes talking about a wedding you went to and try to be social and all that. So what's your method?
All right. So from the get-go, not talking about when the for cause people come up, but when just the start of jury selection, right?
Yeah.
So I have a little spiel. You guys are interviewing all these great trial lawyers, and what I've done, and most trial lawyers do, is I've stolen a little bit from everybody, and then I put a little bit of Zaner spin on that. I got some Dan Ambrose in there, perfect justice. I got some Mark Lanier on there, lawsuit abuse. I got some David Ball. You got to mix some David Ball into your jury selection. So I've got all of that. But for my opening, it's kind of like jury empowerment. I give them a little speech. Everybody, thanks for coming. I know as a lawyer, I got the jury notice once upon a time. And as an aside, I try and be truthful. I don't think people should make up scripts. They should be authentic. I think that is probably the most important thing when you have 15 to 45 minutes. Is like, I don't want them to hate me. They don't even be my best friend, but I need them to know that I'm telling the truth.
If you have 2 fucking days, be authentic. Don't, it doesn't matter. I mean, I totally agree with you. Don't steal someone else's script. I mean, Keith Mitnick has great foundation for a lot of this stuff, a lot of the people you named, but it's like you said, you got to make it, you're like truthful to like truly something that you actually experience in real life.
Right. So I tell them I was excited when I got the jury summons. I was going to go in there and learn how it all works from inside the courtroom. But of course, it came on a really busy week. The kids, I throw my kids in there, the kids had a lot of practices and work was going crazy. And I didn't want to show up, but I did. And so did all of you. And all we're trying to do in these next 15 to 20 minutes is trying to figure out if you all can be fair jurors for this case, because we have all these experiences that make us great humans and great jurors. And those include biases and opinions and thoughts and beliefs. And we want you to have those because those make you good jurors. But sometimes those make you unable to serve on a jury for this kind of case. And so we're just trying to explore those. I'm not trying to pry. I'm not trying to put you on the spot, but we do have to ask you some questions. And, and then throw Keith Mitnick in there maybe. It's like if I was asked to judge a pie contest, I hate pumpkin pie, and if there's I know it's going to be on the ballot, I'm going to be voting against that no matter what, because that previously held belief, this opinion that I've developed over years of mom's Thanksgiving dinners is not going anywhere. And that's all we're trying to do. There's no jury jail if you answer this wrongly. If the judge behind me who looks scary in the dark robe looking down on you asks you if you can follow the law, it's okay to say no. They're not going to put you in jury jail. So all we're trying to do, both us, defense lawyers, and also the judge want is some brutal honesty. We just want you all opening up and letting us know what these experiences are that make you a unique human and whether they can fit into this case, because the rules inside this courtroom are very different than the rules outside. The way you want to act and believe and have a conversation, very different here. And can we follow the rules? And that's it. And then it's about a minute long, maybe a minute and a half. I speak fast so I can go that way. And then I just segue into brutal honesty just to get them talking.
Which one of those was the Zaner spin? The famous Zaner spin?
There's more Zaner spin towards the end. I mean, I'm sure everyone influenced me on that on some level. I did have jury selection. That's all legit. I used to make some jokes about the upside down when Stranger Things was like really popular. You get stuff the upside down. The other thing I do before we get in there, when that happens, I memorize everyone's name. Did you guys talk about this in all your other podcasts? Like,
we actually haven't talked about that yet.
It is so powerful. I'm telling you, it seems like a parlor trick, but I'm telling you that I've had jurors come up to me at lunch in the middle of voir dire and say, "Thank you for memorizing our names. It shows that you really care." And it ain't that hard. You just do 3 at a time, use some mnemonic devices. There's this great book called Moonwalking with Einstein about Cicero's memory methods and how he used these memory methods to be a great trial lawyer to remember things.
We're like, just for the record, we're like 8 minutes into the podcast, and it's a little longer than I thought it would take Kurt to mention Cicero. So, I think the over under, the betting line was like 5. So I think I took the over.
Let the record reflect. And then I lead into it and I say, Mr. Smith, brutal honesty, what does that mean to you? And it also breaks down some barriers. I'm not like scary lawyer up there. Maybe I'm a friend. I know his name. I'm a little disarming. So I really think, and everyone's like, I can't do it until they try. I'm like, yeah, it's pretty easy. I think it's worth investing.
So how do you do it? Teach us.
Get all that warm up, right? You got the judge asking questions. And so I go 3 at a time. And 1, 2, 3, I memorize their names. And maybe, I use a mnemonic device, meaning I see Mr. Rocky. I'm like, oh, Colorado Rockies. He's the Colorado Rocky guy. I see Miss Smith. Oh, okay, Mr. and Mrs. Smith, the movie. And I do that. And I just go, I do them in my mind, 1, 2, 3, Miss Smith, Mr. Rocky and Miss Zaner. And I go those 3 until I got them. Then I move to the next 3 and I memorize those 3. And then I make sure, then I try all 6 at a time that I've done now. And I just kind of go, okay, that's Miss Smith, Mr. Rocky, Mr. Kramer, Mr. Plotkin. Then I go the next 3, just 3 at a time. But every time I get a new 3, I make sure I know the ones prior to that. And I go back and forth until I can do all 18. And it takes like 10 minutes. It was challenging in the last trial because the judge didn't have them seated in their seats. And I just had the seating chart. And then he just excused some people right before they got up there. And so the chart changed. And that was the best challenge I've had. But I still managed to do it. So I highly recommend that.
I've had a friend who does that. And I think the key to doing that is you can't like try to show off and draw attention to it, because I did see another lawyer once. This was crazy. He got up there and he just goes, the first thing he does with the jury is he goes, Mr. Jones, Miss blah, blah, blah. And he just listed their names. And the jurors are looking at him like, what the fuck are you doing? What's the deal? He's just showing off. But my friend who does it, and I'm sure this is the way you do it, is just like, if you're just like knowing they're just like, even if they don't even realize what you're doing, they're just like, oh, this guy's listening to us. Like, and especially if you're like, hey, and I know you're a nurse and you work in labor and delivery, and they're like, and you don't have any notes, you're not looking at it.
Right.
They're like, oh, this guy is actually listens. And that's a huge thing for a lawyer to accomplish, because I think the rap on lawyers is like, this guy doesn't care about us. He's just taking a depot or whatever.
Right.
And if you actually hear what they say, how many times have you seen, the flip side of it is, how many times have you seen like a defense lawyer get up there and ask some question that was already asked like 2 times, like, what did you do for a living? And they're like, this guy already wrote it on a questionnaire and the judge already asked them and you're just not even listening. And the jurors are super annoyed.
Or worse, they'll like confuse the Asian people and like call one Asian person the other, like you see that kind of stuff, like where they just it's like, dude, that's just real bad. I've seen that many times, unfortunately.
I saw one defense lawyer go, be surprised that, what do you do for a living? And this lady, she was a lawyer, and she was like, I'm a lawyer. She's already annoyed. And he was like, lady lawyer. Oh, well, I'll ask you a question, lady lawyer.
Oh my God.
Yeah, I think that's awesome. Just showing them that you listen to them is a huge part of building credibility. So I love that. Yeah.
And it breaks down that, like as you were saying, Harry, that image of as lawyer. Look at me as a person. I'm not Mr. Fancy Lawyer. You're a fancy lawyer, you're going to lose, I think. I think we've got to do everything right to win on the plaintiff side, and that's being authentic. And so, as we talked about a second ago, so I don't go up there and announce, I have now memorized all of your names. I am masterful. Respect. We just, and you mess them up sometimes, okay? And they give you some, like Mr. Like this is hard, and they give you, they're okay. No, it's Mr. Smith. Well, that's right. So yeah, you got to have some fun with that. The rapport building, I think, is something I really enjoy.
So are you? So I assume you're not taking. Are you taking any notes or seating chart or anything up with you? Or are you just open? Yeah.
Just nothing, no notes, no seating chart, nothing. If I'm, I have like 15, 30 minutes. If I can have a cheat sheet to the left of like my topics, but I obviously know where I'm going. That's the benefit of having 3 days, not a lot to remember. You're just going up there and hit the hot topics.
So you get up there, you do that, and then 15 minutes, boom. Like you gotta, what's the first thing you're gonna do? Are you doing group questions? Are you going one by one? What's your method?
I go one by one. I start with brutal honesty really briefly just to get them talking. And then from there, I go into a quick empowerment thing. How do you feel about the jury system and being vested with this immense power? I mean, even though you got 15 minutes, the big points for me, like I want to build a little rapport. I want them to trust me. I want them to feel empowered, and it's just so important. It's worth a minute or two. I really think it is. Maybe a minute. And then I go into the toxic topics that I want to make sure they're going to be okay on. How do you feel, Mr. Kramer, about being vested with this immense power? Because I like to use that in closing. Then remember I told you in jury selection, the power you'd be vested with. I think it's like a Carl Bettinger thing. No one talks about Carl Bettinger anymore. His book's amazing.
No, it is good.
And I'm showing my age here, the old books I used to read. And so I do one by one. And I say, no, and then I'll pull in the group thing. And who agrees with Mr. Kramer on this one? Show a hand who feels differently. So I'll go, person by person. And one of the things I was thinking about and thinking about this podcast is there's a real inclination when you get good answers to stop talking to the person. And that's true when you only have 15 minutes. But I think it's important also not to completely neglect them because maybe like they're really bad for you on some other issue, and you can't assume that they're a one issue voter. In so much you can afford to use your time that way. So back to your question: start with brutal honesty, go to jury empowerment, and then I go into lawsuit abuse.
Okay, I want to talk about talking one by one, Harry. It seems like I forget if you and I spoke about it or Claire and I spoke about how you're starting to go towards the more talking to each juror individually, like go down the line. Yes, or no?
I like to have, I like to, especially if it's a real short voir dire, I like to have at least one question that tells you about liability that you ask everybody, because I want at least one question where I can assess them. Like, are they going to be really good? Like, and not only are they going to be good for us on liability, but like, how good are they? Like, how serious are they? And it has to be like no right answers, no, not yes or no question. I think you got to do that one-on-one with them, whether you don't go down the line or whether you just make sure you hit everybody. I just don't like group questioning just doesn't, raising hands. There's so many people who just don't raise their hand who have even the stronger views than anybody. They just don't do it.
On that, Harry, I do want to, because I think this is a very important point for our listeners, is talking about liability. And we recently had an admitted liability trial where you wanted me and Claire wanted me to spend some time talking about safety rules and following safety rules. And I'm like, dude, I got to do the whole room. I don't want to talk about, waste my valuable time. I had a very short amount of time like you usually get, Kurt. And it was like, they're admitting fucking liability. Why am I talking about liability? But I'm so, like you both convinced me that it's super important, and I'm so glad we did, because we did find out the people who follow the safety rules are the ones who are going to get really mad at the defendant's actions, even if they admit liability, right? And the ones that were more loose on it were not as good on damages, and it really does tie together that I think is often overlooked, or we don't even really consider it. If you don't have a jury consultant with you, you're thinking, I'm just going to talk about damages. But I think you're right. In every single case, even admitted liability, you should talk about safety rules and how people feel about it. Kurt, what are your thoughts
on safety rules, or talking juror by juror?
Well, on safety rules first, and then we'll come back to the jury by jury.
Or do you mean by safety rules? You just mean like about talking about liability, even when
talking about liability and people that not
contested.
Yeah, well, especially like when it's not contested. I think obviously in a liability dispute case, you got to talk about it. But
yeah, I mean, if I only have 15, 30 minutes and it's submitted liability, I don't do a lot of liability questions, and it could be wrong. I mean, it's another thing about jury selection. There's a lot of ways to skin that cat. Who skins cats? I don't understand where that expression came from. In my last trial loss, I'm reflecting. Should talk maybe a little less about money, more about liability, more about liability theories. I mean, I want to get them, like I said, get rid of the tort reformers and introduce the concept of, I didn't talk about this yet, introduce the concept of burden of proof and kind of lay that out for them to give people some talking points within that jury room of how light the burden of proof is to help fight for you. And then going into money damages, and then how much is too much. If we're going for nuclear verdicts, large 7-8 figure verdicts, I really like introducing that concept early. We had a chance to talk to one of the jurors in the loss we had recently. Terrible juror for us, but very nice guy. And he was very defense minded, works in oil and gas, et cetera, et cetera. And he was okay with the money ask. He was like, you did a good job of talking to us and getting us ready, getting that sticker shock off when you're going to ask for hundreds of millions. And it all made sense to us. I was like, we didn't give it to me. He's like, yeah, we didn't think they did anything wrong liability wise. I was like, okay, well, that's. And I always wondered, how much does that factor in? Does the ask, if it's too much, factor into liability determination? I mean, does that raise the bar for you, the burden somehow, if you're asking for more money? It's an interesting concept I've been ruminating on.
I always teach that every verdict is punitive to every juror. It's like, how much should I give a huge verdict, a middle-sized verdict, a tiny verdict? It's really more about how pissed off they are and how much they think the defendant should deserve to have to pay. And I actually had a juror, like, I don't know, less than a year ago, actually say that. And I'm like, and I always teach lawyers, like, this is what every juror thinks. And they were like, well, we were talking about, big damages. And he goes, well, it depends on what the defendant did, and it's like, and the judge is like, no, that's not what, that has nothing to do with it. But, you could tell all the jurors were like, yeah, they were all like nodding their heads like, yeah, yeah, yeah. And so, I mean, that's the funny thing is it like, is a life worth 100 million? Or what's the difference between giving somebody 100 million or 10 million or 1 million or $100,000 for, it's not going to bring them back. $1 million's a lot of money. 10 million's a lot of money. 100 million's, I mean, but it's just like for the jurors, that's how they justify it, is like, how much do they deserve this to defend it? If it was an honest mistake and they were negligent, why should we have to give 100 million? I don't think you'll ever find a jury giving that much. But if they really get pissed off and they're like, this company is irresponsible and they're knowingly. So the more I think you get them, the better jurors you have on liability and the more you get them pissed off, that drives damages to me more than even how the jurors feel about damages, because I've had a lot of jurors who are probably in most cases wouldn't be big damage jurors. But if you strike a nerve with them on that particular issue,
right,
they can go crazy. But 15 minutes is not a lot of time. I'm not faulting anything that you do in 15 minutes. It's just so tough to do. It's just so crazy.
Well,
yeah.
So on that note, if you think it's a case where there's an opening to really piss off the jury given the defense actions, are you spending more? Would you want your lawyer to spend more time on the liability stuff? Like, how would you approach jury selection? I mean, well, how should we all approach jury selection there if we're trying to get the piss off points,
Right. I mean, the example I give is the one that I did with a buddy of mine in San Diego, where the judge gave us 30 minutes for 32 jurors or something like that, which, Kurt's thinking like, that sounds pretty great. I mean, I know 30 minutes is more than, the 15. And I just said, I want you to ask this one question each. I don't care if it takes you 20 minutes to ask each one of those 32 people this one question. And when he was done, it took him like 22 minutes or something like that. And I was like, I have a really good feel for these folks, even without talking about damages. And then I was like, spend the rest of the time talking about damages with like these 5 or 6 that I just wanted to make sure about. I mean, I don't think you ever skip damages. I think you got to talk about it and get them thinking about it. But I don't think you have to spend a huge amount of your time, if that makes sense. Because I think liability, knowing how a juror is going to feel about liability, are they going to be really offended or not that offended, tells me a lot about it to begin with. But if someone were to sit down without talking about damages, I wouldn't be thrilled for sure.
Interesting. Kurt, I'm curious. So in this last trial, you said, I imagine, did you do a mini opening in that case where you were able to talk, saying, I'm out to ask for hundreds of millions?
No mini openings. I've never had a mini opening allowed in Colorado.
Could you even talk about the damage number?
Yes, we're allowed to talk about the damage number. Yeah,
okay,
that's right.
Well, so show us how you introduce that and at what point in the voir dire.
Yeah, no, great question. So I remember the first time, my first 8-figure verdict, probably read some Nick Rowley book, Trial by Human. I'm like, I got 5 minutes. I'm going to talk about, money first. And I thought that was a huge mistake. So I mean, right out of the bat, right out of brutal honesty, I'm like, in this case, I'm going to be asking for $20 million. And this is before I developed any rapport with the jury, any authenticity. I didn't get them warmed up at all. And people were fucking mad. There was this guy in the front row who ultimately got dismissed. I asked him to be struck for cause because he looked like he wanted to punch me. And the judge granted my request for cause, saying that the juror had displayed physical enmity towards Mr. Zaner. And so he can't be fair. We're going to strike him. And that was right out of the gates. And I mean, look, we still got 16 million. That's the one you were talking about earlier, Dan. It was the largest premises liability, not the largest injury one. So there's bigger injury ones.
We're not trying to get sued at picking justice.
And so, I mean, trial lawyers do that. Trial lawyers, they sue anybody. Now, we still did great, but I don't think that was the right approach. I like to get them warmed up. And that's one of the last things I ask them now. First, the things I talked about before. Then I start going through tort reform, lawsuit abuse. the idea of money for impairment or pain. We call it impairment in Colorado because we're capped on pain and suffering at about $1 million to $2 million. The law is changing, but that's with an increase in the cap. And now it's a whopping $2 million. Before it was about $1 million. I lay foundation where I get them at least to trust me a little bit. So, I think if you do it right away, it kind of feeds into that greedy trial lawyer-driven litigation that we're always fighting against. So I think it's smart not to lead with it and go with it at the end. And so, I talk about, money, the concept of a lawsuit for money damages. We start there. And we actually kind of start before that, but we can go to the money part. You go to talk about lawsuit abuse. Mark Lanier has this great thing on lawsuit abuse. People hear about lawsuit abuse and they think about, runaway juries, frivolous lawsuits, jackpot justice. But there's another kind of lawsuit abuse out there. And that's when a defendant corporation has clearly done something wrong. Instead of taking responsibility, they say, talk to our lawyers. We're going to peer into your lives. We're going to make you meet with our doctors. We're going to force you to go to court, and we're not going to pay you what we owe you. That's also lawsuit abuse. And who thinks there's too much lawsuit abuse out there? And that's kind of fun. It was a fun one because you always think about it on our side, but they should know that it goes both ways. So I do that. Then I talk about the idea of the concept of money for damages in a lawsuit. And this is where I use a Dan Ambrose thing. I say, look, there's no such thing as perfect justice. We can't spin the world back on its axis and put Mr. Strawn back together who's lost a leg. We can't give him his job back. We can't give him those moments with his child back. But we can render a verdict here where we award money damages to help balance the scales. And everyone's shaking their head. And how do you feel about this concept? Great. Then we do we go that back and forth. And what about the idea of money for medical bills? It's David Ball thing, right? And everyone feels pretty good with that. Yes, we do. Great. And then I shift for a moment to burden of proof because I want them to know that we only have to prove the money damages by the burden of proof. And again, I save that money damages for the end. And when I do burden of proof, this is kind of a Zaner spin, is I talk about the 3 levels. No one ever talks about clear and convincing because I really want them to know how light the standard is. So we go, why do we have beyond a reasonable doubt for criminal stuff? Can't take away people's liberties. I go, there's another standard in the middle between where we got to prove and below that, and that's what we call clear and convincing, highly probable or reasonably certain. You have to be reasonably certain of which side you're taking. I go, we don't have to meet that burden even. What we have to meet is just, the 51%. Is it more likely true than not what we're saying? And so again, getting these layers, I think, is really helpful and warming them up that, look, we're going to prove everything by a lot more, but this is all we have to do. And is that unfair? Is that too easy for us when there's money damages at stake? So I go through that, and then we wind up to, how much is too much. And that, I think that is a Zaner spin, I think it's that.
No, I haven't heard the clear and convincing. I like that. I'm going to steal that. I want to hear how you talked about hundreds of millions, because that is massive, massive amount to talk about in jury selection. So how did you introduce that number?
Right. So I say, look, now we have to talk about something that's very uncomfortable, and that's damages, and the amount of money we'll be asking for. Some folks, because of all those opinions we said that make you good jurors, are unable to sit on a jury where they're asked to award, large amounts of money. And let's break it down and let's think about it this way. Who's heard of the F-22 Raptor jet program with the government and the fighter jets? So maybe I have. Those planes cost $168 million for one plane. The entire government contract was $22 billion. And Lockheed was late in that, and they were over budget, and it cost the taxpayers hundreds of millions of dollars. I go, and so if the government brought his lawsuit to get back taxpayer money, billions of dollars, who would feel uncomfortable sitting on a jury because it's such a large number? And even though, it's taxpayer money, it's black and white, there were delays, they just, because of their own ethics, don't feel like they could sit in a jury that awards billions of dollars. No, some hands go up. We go, there's other examples. Maybe Microsoft is suing Apple for software infringement, and Apple owes Microsoft $4 billion because they stole the software and made a bunch of money off of that. Some people would say, well, look, corporations, I can't award $4 billion. We go through some of that. And then I keep layering it down to get more similar to the situation that we're in. I go, now let's take another example. Let's talk about maybe instead of Apple suing Microsoft, it's Apple suing an individual suing Apple, because they were the software developer. Now we have a plaintiff, right, as opposed to corporation. And they were damaged, $800 million because Apple stole their software and didn't pay them and they got all the royalties off of it? Could you sit in a jury where you award a person, not a corporation, the government, but a person, $800 million? If the defendant is not a corporation, I would go one layer down and person versus person. I haven't had one of those in a while. And so now we've introduced this concept of some individual can get back from a company in what would probably seem like black and white terms to them, hundreds of millions of dollars or billions. And so people are getting used to this. Well, yeah, these kind of things happen all the time. And then we transition, and I do a Mona Lisa transport thing, and there's a Rex Paris thing I stole. Who knows if he got it from somebody else? And I build in the facts of our case into the transport of the Mona Lisa. So, for example, in this fracking case where we had 15 minutes for jury selection in federal court, I thought it was 20, and then I got up and the judge was like, "You get 15 minutes." I was like, "Great." It was all about these fracking tanks. Fracking tanks are like the size of a mobile home. And my guy was on top of one of them, just to cut right to the chase, and it exploded. And so the whole theory of the case is that the company that delivered these fracking tanks, these mobile home type units, to the fracking site, they delivered them with holes, which let air in, which created this explosive environment with all the methane that was coming out of the ground, and it exploded. And our theory of liability was that they didn't inspect these things, these tanks. They didn't make sure there were no holes in them. They didn't certify they were safe before providing them on site. And so then I go into this damages routine. I go, let's say a company was hired to transport the Mona Lisa, priceless piece of art. Their job to transport it, the way they decide to do is they put it not in a solid wood secured container with all the little packing bubbles and the frame inside, but they deliver it with an old rusty box with holes in it. And they never even check to see if this box has holes, if it's secure. They don't create any forms to make sure that the box is secure. And lo and behold, when they transport it, the Mona Lisa gets damaged. And that's worth $800 million. And so I build in the facts of our own case. No one ever objects to this, the liability of it. And now they've like, well, yeah, if you do something like that with something that's priceless, our plaintiff is priceless, we can award those damages. And then I go into, all right, so listen, brutal honesty. I know this is more than 15 minutes. I do a little.
I was going to say, dude, how much time do you actually, are you
this? I did this
us
example in the federal court trial. Boom, no problem. I just, I don't put as much elaboration as I am today for your listeners. And I say, look, I said, brutal honesty, circle back to that. I'm going to be asking for $40 million in this case, who, because of their life experiences, wouldn't feel comfortable awarding this kind of money. And we haven't proved a thing. And we don't want sympathy for the plaintiff. He's hurt, so we want sympathy for the defendant. How are they going to pay for it? These don't come into your analysis. Who could sit in a jury, or who couldn't sit in a jury and award this kind of money? And if no hands go up, you go one by one. And you talk to them and you ask them. So that's the
I like that. I mean, I know I love the concept. I really do, about scaling it down. I think that's great stuff. Harry, what do you think about intertwining that into jury selection?
Yeah, I mean, the thing that I actually liked the best of that a lot of lawyers make mistakes on, Kurt, was when you said, and if you get no answers, you go one by one. 99% of lawyers just move right on. They're like, oh, no hands? Okay. To me and to you and to Dan, I mean, it's like, when you've been doing this long enough, it's like, no hands up just means no one's talking to you. It does not mean, oh, wow, this jury is amazing. Anyone here ever got a speeding ticket? Nobody ever? Okay. Move on. It's like, no. So it means, okay, this is a quiet group. I got to do the work myself and talk to them. And if you talk to them one-on-one, they'll actually start talking to you. It's a lot easier. But when they're not like, being talked to directly, these group questions, people just kind of easy for them to kind of just hide, go, he's not really talking to me. I don't really want to talk. But in terms of the damages, yeah, I love talking about one of the things when we had Randy McGinn on here recently, who used a very similar example. And I always like to, when jurors have an issue with it, I always like to use that example. Hey, if a person was to drive into a building and do $10 million of damage, what would your award be, even though it's an individual? And, most people are like, oh, I guess it's 10 million. And you go, okay, tell me why it's different if it's a person and their quality of life. Why does that change how much an individual should have to pay if it's not a corporation? And like Randy said, sometimes they'll give you answers. Well, then I worry about, how it's going to affect them or whatever. But I love using another example about that they can get behind and then say, how is this different? Why is it different if it's a person? Why is it different if it's who you're suing? Things like that. What's the most interesting answer you've ever gotten from somebody on one of those kind of questions of how, if it's not the Mona Lisa, we're talking about a person?
Yeah, I mean,
What do some of the jurors tell you?
some will just say, that's just too much money. I don't feel comfortable. I mean, how could any damages be worth, $20 million? I would need to see lots and lots of proof and what are the damages in this case? But we can't really talk about that right now, sir. But we're going to give you mountains of evidence to show you what we have. We're not getting into case specifics. The judges want us doing that. Well, I just couldn't do it. This is just, that's just ridiculous, a ridiculous amount of money. You just get like the vitriol.
And you don't fight them, right? You don't go like, well, the law says, I totally appreciate that. I'm not going to change your mind, right? I mean, that would be wrong for me to try to argue with you about it. Is anything going to change your mind in this case? Is all the evidence going to change your mind? No, And so then they're your friend. You're helping them. You're not arguing with them. You're not challenging their convictions. Like you're their buddy.
I never try and argue with them. And I think most of us would agree with that, especially when you have less time. I mean, even had this problem 15, 30 minutes, like spending any time on strikes is challenging because you're going to run out of time. And we get our 5 peremptory challenges, and I use those. I don't do. And you can kind of feel the judge early on, but I feel like the judges in Colorado, maybe it's our case law, I should probably read that sometime, is just not great on for cause challenges. So I don't spend, when I have 15 minutes, it's like, do I want to spend 5 of it trying to do it or just find out maybe there's 4 other bad jurors I just need to get rid of? I don't spend a ton of time doing that.
Anytime you're limited, you can't spend a ton of time on cause because at the end of the day, it's up to the judge. So you got to just one phrase, real quickly. I mean, one I think that's been working, I know I've been doing in my cases with Nick that Nick has been using is just, I appreciate that. Like, is that going to put the way you feel going to put us at a disadvantage and put the defense at an advantage? And I think that's language that a lot of judges, it's hard to argue with. Like, the person said that I'm at a disadvantage. And because some judges will be like, well, just because you're a little bit behind, that doesn't mean they're biased. And, I used to use uphill battle. I still like uphill battle. Are you saying we're facing a pretty steep uphill battle? I think most judges should give it to you, but I'm always looking for the best language. And I think disadvantage is a really, really
Yeah, let
good
me
one.
ask you this, Harry. So on the last trial, I used hey, I think it was, we had a former employee on the panel. I was like, and who thought the defendant was great. And I said, hey, I mean, look, you used to work for Terumo. If we're in a race, we're starting the race, and this is Terumo, and this is the plaintiff. We need to, are they ahead of us before we start? Do they get a head start ahead of the plaintiff? Yeah, I think so. I mean, I thought that judge didn't really think that was a big deal. What do you think that's a good metaphor to use? Sounds like you got some better ones you're cooking up. What do you like?
Yeah, I think there's better ones. Because I've had a lot of judges who say, that's not enough. And some of them will even say, well, you have the burden of proof, so you are starting behind. I've had them say that. So they're accurate. They're just following the burden of proof, which is like, come on, that's not what they're saying. So yeah, I think it's got to be something really strong. I mean, I think it would have to be like, are we pretty much in your mind lost this race? If they say yeah, but I think for me, the one that works best is just like, are we at a big disadvantage, or are we facing like a real uphill battle where you'll listen, and that incorporates like the defense saying, but you'll listen to all the evidence and follow the evidence, right? You'll listen, but I'm in a deep hole that I got to dig way out of. And I'm facing a real uphill battle, and in your mind, I probably will never overcome that, right? Yeah. If they say that, that's fine. I think when you use that analogy of the race, I've had jurors go, how far behind am I? And you walk it out sometimes. And I've had jurors go, keep walking or whatever. Like, you need to leave the courtroom. When you get them to quantify it, a lot of times judges go, oh, shoot. If we're supposed to be starting the race, how far am I behind? They're like, you're 100 meters behind.
Right. And is that enough?
That makes it easier. Yeah. All right. So want to thank our sponsors again. The first one is Verdict Videos. Kelly Deutsch. If you don't know Kelly Deutsch and Verdict Videos, welcome to the Plaintiff Bar. I know that, for Dan and myself, we work a lot of the same cases. I know for my wife and I, we have focus grouped their videos in focus groups, and jurors have loved what they've seen of these things. I've seen the increase in value and the settlement value of these cases is sometimes tens of millions of dollars more after the jurors watch their settlement doc videos or day in the life videos than before they watch the video. And day in the life videos, I don't know if you use them, Dan, but they're not just for trial. Settlement videos for mediation are an effective tool for trying to settle cases pre-lit too. I'm sure you use both of them.
Yeah, I mean, the best thing about working with someone like Kelly is that you're not handed off to some, other person, or you're just dealing with projects. Like you will get Kelly's cell phone. She knows how to talk to clients, and I think that's one of the hardest things when someone's to be invited into their home. She'll talk to the client. She'll sit down with the client. She knows how to tell a story, and she's just such a wonderful person, like truly empathetic, compassionate. she really understands what a client's going through, and that shows through in her production. And she's wonderful. We love her. She's just she contributes to the community. I know through LATLC, the charity, and all that. She's just a great person. Very easy to work with. Great pricing, and really will add a lot of value to your cases.
And I know what a lot of lawyers that I talk to love most about Kelly and Verdict videos is they are always honest about whether they can help or not. I know there's cases where she has said, I don't think I can in this case, but I know that she's told me, our motto is video can hurt you as much as it can help you. And so I know she is actually cares and is strategic about how she can help in these cases.
Which is very true. I think in general, like everyone's like, oh, I need to have the best animation. I need to have this, that, and the other thing. Sometimes less is more. And again, it's great. It's important to work with vendors who are going to be straight up with you and who are going to be honest, like Kelly, and not just want your money from the case. Like, she will be straight up, and those are the best vendors to work with. Another wonderful sponsor I'd like to thank is my dear friend, Melissa Baldwin from Baldwin Settlements. She is a structured settlement broker. She's fantastic. She's one of the first people I met when I became a plaintiff's lawyer, and has just given back, just great advice. She's another one of these people you can call and just, get some advice, and she'll really go out of the way to help you out. She supports CAOC, CALA, all the, AAJ. She's a huge sponsor of all these organizations. Her and her structure team work tirelessly with the attorneys and clients, and she really makes the hard fought result easy for the client. I mean, I had a very tough case from someone who was basically homeless, and she was able to make him understand. He did not have any education to speak of, barely spoke English, but get him to understand how important it was to structure the money, because a lump sum and the many millions of dollars just would not have been good for him, given that, he had some issues with drugs and all that. She was able to speak to him at his level and get him a structure that really set him up for the rest of his life. And she was willing to work day and night, anytime, weekends, just to help get it done and get the best rates she can for the clients. So, and she also does not just structure. I used to think, I'd be like, look, when I was just starting out, my cases aren't big enough for you, Melissa. She's like, no. Like it's not just for the 7-8 figure settlements. It's really for all clients who just need some help to structure. And she can also structure fees, which is great if you want to put a little bit away for yourself and your family later on. So call Melissa Baldwin from Baldwin Settlements. Really great person, great friend. These two sponsors are just wonderful women that I really respect, and they run great businesses and good people. And lastly, we just again want to thank Law Pods for making this possible. These podcasts, their whole library of attorney podcasts, truly help, all of us get better. And I highly recommend you just listen to them. I put them on in the car. I'm listening to all these trial lawyers throughout the country with all the experiences they have. And it's just such a great avenue, because we can't make it to courtrooms all the time, but we're hearing from the best. So thank you for Law Pods for providing that platform. Welcome back, everybody. So we had some good stuff on the cause challenges. Hundreds of millions of dollars. I assume when you did that, you asked that you set it up the exact same way. Right.
That's right.
How many jurors? Was it a wrongful death case?
No, people get cancer.
Oh, right. Okay.
We have a wrongful death cap of like $2 million in Colorado.
Right.
Unless it's felonious or something.
Correct.
Felonious,
that's right, Harry.
yeah.
No, right. And that's a judge determination.
Yeah.
So when you said hundreds of millions, for cancer, were a lot of people behind it, or were there a lot of pissed off
I didn't
people?
get much pushback.
I
didn't get much, and I got them used to those big numbers. And I think my co-counsel was more shocked than the jurors, so that was good. He's like, hundreds of millions.
Clear that with me.
Yeah. we didn't get it, so maybe it was the wrong move, but I didn't feel a lot of pushback from this particular jury. And in the prior trial, there was a $30 million fracking explosion one before that. I got very little pushback, and you can't. There wasn't a lot of time to explore each one of them that much depth. But I turned to my lawyers and I said, look, either we got like the best jury ever, or they're a bunch of liars. I don't know. I can't figure that out.
The 30, was that a wrongful death?
No, that was an amputation. I don't know. There's so much more than that, right? We call it,
Right,
it was orthopedic injuries. He had an open book pelvic fracture because he got blasted off that tank and landed about 30 feet away. came down on his feet, and so for the open book, right, it's like your pelvis opening up like a book.
Obviously, in those cases, I don't think you're going to get it much. I think you get the pushback when you're going to ask for tens of millions for a TBI plaintiff who looks normal, walks in and out of the courtroom, CRPS, client who walks in and out of the courtroom, but are multiple spinal fusions who looks normal from the outside. Those are the types of like where you're going to get that. You got to introduce it, but you're going to get a lot of pushback. Don't you think, Harry? It's like the ones that, like those two, cancer and this terrible initial injury or wrongful death. I don't think you're going to have much of people may roll their eyes at it, but it's going to be like, I think the hardest is the normal looking plaintiff.
Oh, for sure. There's some types of cases where they totally get it and where you're not losing any credibility by throwing out a big number. If somebody has died, if somebody's paralyzed, an amputation, things like that, they're like, I get it, and I get that's a big deal. Yeah, it's those ones where it's like, yeah, they look fine and maybe they have a limp or they got chronic pain, and that people are just like, a lot of people have chronic pain. Not a lot of people are paralyzed or lose a limb.
So then on those, Harry, because those are the ones that a lot of us try.
Right.
And we believe the value is in the tens of millions, for paying the rest of your life. And so are you, and I know you and I have talked about this, Harry, but maybe Kurt, what's your philosophy on talking about money there? Would you say tens of millions? Would you say, I'm going to ask for 40 million for a TBI case or whatever it is, normal looking plaintiff? What's your philosophy on giving a range versus a specific dollar amount in jury selection?
Yeah, I mean, I agree with you. I think especially as you move through trial, they feel a lot better about those terrible catastrophic injuries. Usually in the jury selection, we're not allowed to go into the injuries. So we're dealing with a cold jury regardless, whether it's the amputation cancer or, I've done a lot of CRPS cases, $16 million one, a couple other 8-figure verdicts. I don't usually introduce the injuries and the damages too much when I have 15, 20 minutes. But to answer your question specifically, I do try and work it in. And, we'll talk about, they've got something called complex regional pain syndrome, a debilitating neurological condition that feels like your body's on fire, but really not over the top, just kind of simply stated. And for that, other than this cancer case, the toxic tort, which is just kind of uncharted territory for me, I always give a number. I like a number. And I say, look, we may ask for more, we may ask for less. We'll see how the evidence comes in. But we're asking for $40 million in this case. To me, I've done both. I feel more comfortable with the number. And it seems like we're more confident in it, more certain about it. And I'm sure there's lots of great lawyers that get even bigger verdicts that use a range. But lately, my philosophy is just a number. What do you guys think?
Let me ask you, in your CRPS case, did the plaintiff look normal on the outside?
Yeah, they both look normal on the outside. Yeah, both my two CRPS big verdicts, totally normal.
And you said at some point in your jury selection, I'm going to ask for $40 million for this normal looking plaintiff. That's was that how you asked the question?
I just say $40 million in damages in this case. I don't tie it too much back to their damages and their injuries at that point. I don't concede that they're normal in any way. I just kind of say they see them there. In Colorado, we always have them come for the whole trial, unless it's like a 6-week trial. Well, I don't really, with the time limitations, don't dig in too much. Maybe I should, but don't dig in too much to explaining their damages at that point. I mean, if there's enough time, I do like to have a section on if it's a back pain case, because so many people, as you know, you're like the master at these spine cases, deal with back pain. So we do explore that in jury selection if that's what we're dealing with. And those questions would come before the money question.
So these invisible injury ones, I mean, let's just go down that path for a second. These invisible injuries like TBIs, like CRPS. I mean, do you address the invisible injury in jury selection?
I do if there's time. I'm thinking back to my last one when we had, I think, 30 minutes. I didn't, and we got, I think, a $10 million verdict. Now, I don't think we talked a lot about the injuries.
Harry, what's your, not necessarily a spinal injury, and again, it's like those invisible ones, like the TBI, the CRPS cases. How do you like to voir dire on that?
I do definitely like to, given time, obviously not 15 minutes, but talk about the idea that is, quality of life, is health and quality of life. Is that something that's you think is worth a lot of money, or is just, some people feel like everybody suffers in life and you just suck it up. And some people feel like there's nothing more valuable. I do like to talk about the value of quality of life and getting seeing who kind of agrees and everything like that. Because then you can say, whether you give a specific number or you say many millions of numbers. I don't really like a range. That kind of sounds, to me, I think jurors take that as weak. I think they see that you think you're fishing and they always choose the lower number. If you were to say somewhere between 10 and 30 million, they would say, okay, he's asking for 10 million, and trying to pull something to get 30 million. But anyway, I think that then you can say, are you open to the possibility that somebody's quality of life isn't cheap and it could be worth in the many millions of dollars, or does that just seem ridiculous? And get them talking about that. I will say that if you get a really short amount of time, there is no better way to cut right to the chase and get cause than throw out a specific number. If you're talking in generalities, you have to spend more time talking about it to really maybe get some cause. But for Kurt, is that partly why you do it in a short one, to throw out a number so that you can really quickly say who already just says 40 million? No way.
That's exactly right. That's exactly right. Yeah, I think I've done ranges before, and I think you're spot on. They'll just think it's the lower amount. They'll pick the number that they're thinking of, and obviously we're thinking of the higher number, where we're giving ourselves some leeway in between. So yeah, with limited time, here's the number. If there's no amount of evidence that we could give you that would allow you to comfortably award that amount of money, then you wouldn't be able to sit on this jury. So I like just to laser focus it in. The other reason, and I'm thinking through the questions as I'm listening to you guys answer it, maybe I don't go so much into all the things Harry talked about, is in Colorado, we have the pain and suffering cap. So, and that definition is awful. So our relief valve is impairment and disfigurement, physical impairment and disfigurement. And the way it's defined is anything not included in the other category. So you have to go back to the non-economic damages definition, which is like pain and suffering, impairment in the quality of life, which is the same word we use in the other category of damages, mental anguish, inconvenience, stress, etc. So I don't talk about any of those things in jury selection. I just keep using the terms physical impairment, or if it's an amputation, it's a disfigurement. But for TBI, Dan, it's all physical impairment. Your brain is impaired, and I lean into that. I mean, in our last case, we dropped the non-economic claim because I've lost millions of dollars and the jury just doesn't listen. Due no fault of their own. It's confusing, but puts the money in the wrong bucket. I had a closing where they asked, the jury question, does it matter where we put the money? For example, 5 million here, 5 million there. Is there any consequence for the plaintiff? Follow the law. That's all you can tell them. And what does the law say? It says all the things that the damages really are fall into that non-economic category. So it's a really uphill battle here. And so we just generalize it for physical impairment, the impairment of living with a brain that doesn't function, that doesn't allow you to remember the special moments you have with your children in the morning by the time you come home at night, the inability to make decisions on their behalf to help them with their struggles, whether it's math or life choices. That's what traumatic brain injury is, impairment. That's how we define it. So I'll talk about those kinds of things.
It's such a gray area, what's physical impairment versus suffering. Because, I mean, people's emotional stress comes from being physically impaired. So it's one of those.
We can't say that.
Right. We can't say it, but it's you can't say it, but that's the reality. So you just have to frame. It's a matter of framing it. I mean, like in the last one, we talked about just the idea. Got them talking a little bit about the idea of, is there anything to you what matters in terms of someone's quality of life more than their physical abilities and their physical limitations, and so sort of steer it toward that bucket of things.
Right.
So, but yeah, you're right. You got to be a little bit more creative in how you frame it. But I think it's helpful to talk about a little bit about, what are your thoughts on whether your physical health, however you want to call it, physical, is or isn't the most important thing, or really a super important thing, even more important than, the amount of money that somebody could earn in their lifetime, or the amount of, any asset they could own. Anything. It would feel like a mansion is worth more than someone's physical health. And no, here's why, So, just get that idea out there and then just say, could it be worth this much money? I think is super helpful. But I think you have to always frame non-economic damages or physical impairment in the most positive way, so that your jurors are thinking about it in the terms that you're going to be arguing. And then you don't get any false negatives of people who just are like, I don't know, that seems crazy. They're like, no, I think I could do it. As opposed, and you know for sure the people who are like, no way. You took your best swing at selling them on it, and they're not buying it.
Right.
But it takes a little bit of time to do, and unfortunately, which is why it's just so rough when judges give you a minute or less per person. It's crazy.
As the CTLA, are you guys trying to change those laws? I mean, is there any possibility to increase time for voir dire or change these caps? Or, I mean, I'm sure you guys do all the work to make it happen.
I mean, we just celebrated a big cap victory where the non-economic cap went from 500,000 to 1.2 million. Woohoo! And the wrongful death cap went from 500,000 to 2.2 million. And that means we'll probably never revisit again for their 10 years and deal with this awful cap still. Which, I mean, that's the thing. Like, the people like me are frustrated with it because we're going for these large verdicts. A lot of lawyers, are just happy to get their settlements, and that does increase the value, and it helps a lot of people. So I don't want to begrudge the effort. I think it's great. It's going to help a lot of people, but for those catastrophically injured folks, it doesn't provide much of a relief valve. Thank God we have the physical impairment disfigurement relief valve, imperfect as it may be. At least it's there. So I don't see us revisiting the caps anytime soon. The jury selection, I'm on a committee, I think, to help change this. John Campbell, he funded a study a couple of years back. We worked with him. He's from Denver. Oh, he lives in Madrid now, which is way cooler. And so we're trying to do it. And we're a very blue state. So in theory, we should be able to do it, but we're not making huge inroads as of yet. I hope we can change it. But at the end of the day, I mean, unless you get a statute or a rule passed, the judges have discretion, and they're just so used to this 15 minutes to 45 minutes. It's hard to get them off that, not in their courtroom,
Yeah, in California, we recently got the law passed that says they can't put arbitrary limits on any voir dire.
I like that.
It's still in their discretion, but I mean, it doesn't. I mean, we still, Harry,
that doesn't stop anything, really.
It's helped a little bit, though, hasn't it? Don't you think? I mean, it's better.
There's a few judges who were like, I wish I could cut you off, but I can't. But most of them are just going, and you go in there and they're like, this judge always gives 30 minutes. And they go, you're going to get 30 minutes. Not arbitrary, though. It's I thought about it. You get 30 minutes, and you're like,
exactly.
Okay.
It's never arbitrary.
So the lawyers that passed this left the word arbitrary in there. We didn't put a time limit. I mean, we got a a minimum.
There was concern about putting in an exact time limit, I think, because some judges are giving more. So if you put a floor in there,
right.
Or a ceiling, I guess. But Kurt does great work with CTLA, Colorado Trial Lawyers Association. I had the honor of speaking there in Aspen. It was Aspen, yeah. Last year. It was beautiful. It's a great conference. I recommend people from out of state going. It really is really well done. Great people. You guys got some great attorneys out there. It's a statewide organization. Kurt, you were past president or you're going to be president? What's
I've never done the leadership track. I've always been more involved in the AAJ. Guess how me and my partner kind of split it up. He was doing CTLA. I was doing AAJ. So I was chair of the new lawyers for all those years, and board governors and all that AAJ stuff. And now for CTLA, I organized a convention. I like the education part of everything. So I just focus on that. I don't love the politics, the fundraising, the meetings, the board votes. I just like to educate this kind of stuff. So that's where I pour my heart into now, and bringing in great speakers like Dan Kramer. Harry, we got to get you out here. Have you
should get out there.
Yeah. Anytime.
You available? We got a roster to fill. You available? Vail, August 7th and 9th?
Maybe we could do Picking Justice on the road, Kurt. Come on.
Ooh.
Yeah.
No, it is great. Oh, it's a Vail, huh? There you go. Kurt, it's been a real pleasure, man. We've been buddies for a while, but it's great to see all your successes and you crushing it out there. I learn a lot from talking to you. Keep knocking them dead, man. I know you will. So we really appreciate it. This has been very helpful. Great stuff.
Yeah, thanks for having me on. You guys are awesome. You guys are legends. So it's cool to be on the podcast and get to learn from you guys as much as share stuff. So thanks for making the time for letting me come hang. I really appreciate it.
Thanks, man. That was fun.
Yeah, thanks to our sponsors. And as always, thank you to Law Pods for making this possible, for really providing education for so many lawyers out there. I love all their podcasts. Go to their website. They have so many other good ones that I'm sure you'll hear Kurt on because he's on the podcast tour. He's in high demand. But anyway, thanks a lot, guys. Kurt Zaner, sorry. Thank you so much.
Guys.
Appreciate it. Bye.
If you're enjoying the podcast, the best compliment you can give us is sharing it with a colleague who would find it valuable. For all the best clips from the podcast, follow us on social media. You can find those links in the show notes. Have a jury selection story to share? Email us at podcast@pickingjustice.com and we may address it in a future episode. Until next time, remember, you're not just picking a jury, you're picking justice. Produced and powered by Law Pods.